Okay, hey everybody, this is something I kind of been wanting to get off my chest for a while. Ever since this the Kentucky situation with marriage, the Rowan County Clerk, Kim Davis, as you probably heard, she was sentenced because of a refusal to issue same-sex couples a license. Critics of her say that she should be following the law, or she, quote, broke the law. Well, let's take a look at the state constitution of Kentucky. Here it clearly says other prohibited marriages. If you look closely here, between same-sex, right here, along with all these other prohibition of marriages. Another issue with Kentucky state law is, according to this state constitution of Kentucky, the application must be made by a female. The application must be made. The application to be made by female. This is right here. An application for a marriage license may be made by written request of the female. So, according to this state constitution of Kentucky, there would be no possible way for two men to marry each other, because application, according to the state constitution, must be made by the female party. So, if you want to talk about equality, here is clearly, quote, this will put, I'm trying to say that word but I can't. This will break the point of those people. So, how can two men be a female? So that just doesn't make sense to me. According to the state constitution of Kentucky, application must be made by a female. It says, an application for a marriage license may be made by written request of the female. The male may join in the application, but it appears essential that the application be made and signed by the female. Normally, both man and woman execute an application for the license in person in the clerk's office, but only the female signature to the application is essential. So, so there we go. I zoomed in so you can actually see this here, right here. Excuse me. So that's an issue right there with the Kentucky state constitution. According to this, the applicant must be a female. So how can two men, according to this state constitution, how can two men, sorry about this stupid thing, anyways, how can two men be married with this? Clearly states here. So, so that just proves the point. And Kim Davis was elected. Kim Davis was elected to protect. She vowed to follow the state constitution. And here we go again. This is right here. This is what's actually in the state constitution. Other prohibited marriages. If you clearly look here, same-sex marriage is prohibited according to the Kentucky state law. It says other prohibited marriages. Marriage is prohibited and void with a person who has been adjusted mentally disabled by a court of competent jurisdiction, where there is a husband or wife living from whom the person marrying has not been divorced, when not solemnized or contracted in the presence of an authorized person or society, between members of the same sex, between more than two persons, except as provided in subgraph 3 of this paragraph, when at the time of marriage this person is under 16 years of age. Okay, that's right there. In case of pregnancy, the male, female, or either of them is specified in subparagraph of 1 or 2 of this paragraph may apply to a district judge for permission to marry, which application may be granted in the form of a written court order. In discretion of the judge, there shall be a fee of $5 for a hearing, such as application. For purposes of this section, parent, father, or mother means natural parent. Lucky for another issue here too is, according to the state constitution of Kentucky, there are penalties for conducting unauthorized or prohibited marriages, such as same-sex couples. If you look closely, it says 200 right here. It says penalty for solemnizing marriage without authority. Penalty for solemnizing marriage that is prohibited if any authorized person shall knowingly, with or without license, solemnize a marriage such as herein prohibited, he shall be imprisoned not less than 1 nor more than 12 months, or fined not exceeding $1,000, or both. Dang it. Can I get you? Where am I? Sorry about that. Sorry. Let's do this again. Here we go. Right here. According to that is page 1002. Okay. 1002. Alright, so here we are. Oops. Just trying to make it easier for you to read. I have to get. Sorry about this. Okay. So here we are. Okay, again, this is penalty. Here we are. This is penalty for solemnizing marriage that is prohibited if any authorized person shall knowingly, with or without license, solemnize a marriage such as is herein prohibited. He shall be imprisoned not less than 1 nor more months, not less than 1 nor more than 12 months, or fined not exceeding $1,000 or both. And here. Excuse me. Clerk penalty against for issuing clerk penalty against for issuing unauthorized license. A clerk who shall knowingly issue a license for any prohibited marriage shall be fined not less than $500 nor more than $1,000 and expelled from his or her office by the judgment of the court before which conviction is had, and if he or she shall knowingly issue license contrary to his duty as herein thinking to alright where are we? Here clerk penalty against for issuing unauthorized license. A clerk who shall knowingly issue a license for any prohibited marriage shall be fined not less than $500 nor more than $1,000 and expelled from his office or her office by the judgment of the court before which conviction is held, and if he shall knowingly issue a license contrary to his or her duty, as herein prescribed, he shall be fined not exceeding $1,000. If the license is issued by a deputy or other person, he shall be fined not exceeding $1,000. This is a little difficult to navigate here, so if the license is issued by a deputy or other person, he shall be fined not exceeding $1,000, and if the case of prohibited marriage shall be imprisoned not more than 1 year or both. So according to this Constitution, if the clerk approved of any authorized marriage, they've gone against the state constitution. So again, let's look at the prohibitions again of marriage in Kentucky. You can clearly see in 402.20 and E, it is in this other prohibited marriage between, there we go, right here, between members of the same sex. And another issue again is here, where are we? Again, with the application issue, here we are. Again, with the application issue, the application to be made by a female. So it clearly says the applicant must be a female. Excuse me. It says an applicant. Here we go. Again, I'll zoom in again. Here. It says an application for marriage license may be made by written request of the female. The male may join the application, but it appears essential that the application may be made and signed by the female. Normally, both men and women execute an application for the license in the presence of the clerk's office, but only the female signature to the application is essential. So, according to this state constitution of Kentucky, same-sex is one of the prohibited marriages. And second of all, the applicant must be made by a female. The application must be made by a female. So, clearly, there would be no legal way for any county clerk in Kentucky to issue a marriage license to two men, since there's no female in that party. It would be illegal and unauthorized marriage according to state constitution. And as you can clearly see by the penalties of that state, where are we? I had it. Not sure what happened to it. I just have it. Just totally lost what I wanted to criminy. Where is it? I have to find it again. I don't know where it went. Oh, here we go. Here we go. Clerk penalty. Penalty against for issuing unauthorized license. A clerk who shall knowingly issue a license for any prohibited marriage shall be fined not less than $500, nor more than $1,000, and expelled from his or her office by the judgment of the court before which conviction is had. And if he or she shall knowingly issue a license contrary to his duty as herein prescribed, $1,000. As herein prescribed, he shall be fined not exceeding $1,000. If the license issued by a deputy or other person, he shall be fined not exceeding $1,000. If the license is issued by a deputy or other person, he shall be fined not exceeding $1,000, and in the case of prohibited marriages, shall be imprisoned more than 1 year or both. Now you may say that the Supreme Court rule can make laws, but now you say that the Supreme Court is a law of the land. Well, technically, the Supreme Court does not have the authority to make laws. And then we'll check that. Now let's check out the U.S. Constitution. Legislation. Supreme. The court cannot make laws. Does not have the authority Article 1, Section 3. Article 1, Section 3 of the U.S. Constitution. Article 1, Section 3. Article 1. Article 1. Excuse me. Article 1. Section 3. The legislative branch. According to the White House, actually, no, hold on. found it before. Just have to search the history. Histories control. Oops, don't want that. Dude. What is Control H? Branches of the U.S. government. Three branches of the U.S. government right here. Okay, well, after this, looks like it. Legislative, make laws. The U.S. Constitution. U.S. Constitution, Article 1, Section 1, is it? I know I found it before, just trying to find it before. Article 1, Section 1, I think it was. Here we are. Okay, it says, here we are. It says, all legislative power herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Nowhere does it say, in this part of the Constitution, Section 1, Article 1, Section 1, there it says, all legislative. Oh, here, I'll zoom in so you can clearly see it here. Article 1 describes the design of the legislative branch of the U.S. government. The Congress, important ideas include the separation of powers between branches of government, checks and balances, the elections of senators and representatives, the process by which laws are made, and the powers that the Congress has. Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. So clearly, the Supreme Court is not the final rule of the. Clearly, the Supreme Court does not have authority to make laws, and overturning a law is creating a new law, which they do not have an authority of making laws. According to this Constitution, according to our Constitution, the only branch of the government that can make laws is the legislative branch, which is the Congress, which consists of the Senate and the House of Representatives that make up the Congress. So technically, with the Constitution of the U.S. stating the Supreme Court does not have authority to make laws, and with the state constitution of Kentucky, you can clearly see she was actually following the state constitution right there. And if you want to look at the penalties again, let's look at the penalties again for unauthorized marriages in Kentucky. For a clerk, here we go. Clerk penalty against for issuing unauthorized license. A clerk who shall knowingly issue a license for any prohibited marriage shall be fined not less than $500, nor more than $1,000, nor more than $1,000, and expelled from his or her office by the judgment of the court before which conviction is had, and if he or she shall knowingly issue a license contrary to his or her duty as herein prescribed, he or she shall be fined not exceeding $1,000. If the license is issued by a deputy or other person, he shall be fined not exceeding $1,000. And in the case of prohibited marriage, shall be imprisoned for more than 1 year or both. So according to the state constitution of Kentucky, she would be fined or sent to prison according to the state constitution. But since she was following the state constitution, she went to jail for following the state constitution. Completely ridiculous. So here we go. For liberals, the Supreme Court does not have authority to make laws. Clearly look at the state. Clearly look at the Constitution. It says all legislative power herein granted shall be vested in a Congress of the United States, which consists of a Senate or House of Representatives. The Supreme Court does not have authority. The Supreme Court does not have authority to make laws. They can make a ruling, but the ruling doesn't automatically become a law. The ruling only becomes a law when the Congress votes to validate that ruling. So until Congress votes to enact the Supreme Court ruling, technically it's still only a ruling and not a law. So again, Kim Davis did not break any laws. She did not break any laws. According to the U.S. Constitution, and nor according to the Kentucky State Constitution. There were no laws broken from Kim Davis. So technically, the only reason she went to jail was because of her Christian beliefs. There is no such law that says marriage is a right. It's not a right. There is no such thing as a right to marry. Marriage is a privilege, and marriage is a sacred union between a man and woman. There is no right to marry. Marriage is a privilege. So there is no right to marry according to the U.S. Constitution. And then the Bill of Rights. We'll go check the Bill of Rights. Dude. Bill of Rights. Let's look at the Bill of Rights. We'll clearly see there is no right to marry. Let's look at the Bill of Rights. Amendment 1. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peacefully to assemble and to petition the government for redress. Amendment 2. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Amendment 3. No soldier shall be in time of peace. No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war be in the manner to prescribed by law. Fourth Amendment. The right of the people to be secure in their possessions of houses, papers, effects against unreasonable searches and seizures shall not be violated, nor warrant shall be issued but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or thing to be seized. Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless a presentment or indictment of a grand jury, except in cases arising in the line of naval forces or the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of life, nor shall private property be taken for public use without just compensation. Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously asserted by law, and to be informed of the nature and cause of the accusation to be confronted with witness against him, to have compulsory process for obtaining witness in his favor, and to have the assistance of counsel for his defense. Amendment 7. In suits of common law, where the value of controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rule of the common law. Amendment 8. Amendment 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel, unusual punishment inflicted. Amendment 10. Or Amendment 9. The enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Amendment 10. 10th Amendment. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states are reserved. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states are reserved to the states and respectively or to the people. So according to the Bill of Rights, since the Constitution does not there is no right to marry according to the Bill of Rights and the Constitution. So according to the Bill of Rights, that particular issue is reserved to the state, and the state of Kentucky prohibited, along with other prohibited marriages, they also prohibited same-sex marriage and said In their state, in the state of Kentucky, marriage is only recognized between a man and a woman. So again, boom, right there you go. It clearly says right here, only a marriage between one man, that is Kentucky Constitution Amendment 1. We'll check the official Kentucky state site for that to show you. Amendment of Kentucky State Constitution, Constitution of Kentucky. And that is Amendment to Kentucky Constitutional Amendment 1. Kentucky State Constitution Amendment 1. The constitutional So here we are. So in here from Ballotpedia, in 2004, Kentucky became the first state to send a marriage amendment to voters. Voters passed it by a 3-to-1 margin. The citizens of Kentucky voted for this amendment, and here it clearly reads, only a marriage between one man and one woman shall be valid or recognized as a marriage in Kentucky. A legal status identical or substantially similar to that of marriage for unmarried individuals shall not be recognized. And according to the state constitution, what is unrecognized marriages? Well, let's look at the state constitution again. Here. These are prohibited marriages, which are unrecognized marriages. And you can clearly see by D right here. By D, it clearly states. Here, I'll zoom in for you so I can clearly see it. We even put it center right here. And then according to the state constitution, the penalties are severe for a county clerk. So again, Kim Davis did not break any laws. She was following the laws. The only person who broke the law was the judge by imprisoning her because of her faith. There was no law she broke because the state constitution doesn't allow same-sex marriage. It prohibits it. And there's actually a huge fine for it if any unauthorized licenses go out by the clerk. So again, before the liberals say that she wrote the law, they need to look up the state constitution of Kentucky. And they should, by the way, they need to look up the U.S. Constitution too, because the Supreme Court does not have authority to make laws. The Supreme Court does not have authority to make laws. And again here, Section 1, Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate. And according to the Bill of Rights in Amendment 10, the powers not delegated to the United States. Amendment 10, the 10th Amendment. Here, I'll zoom in so you can read it clearly here. I'll zoom in right here. Amendment 10. The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states, respectively, or to the people. So again, there's no law she broke, because the Constitution does not give a right, nor the Constitution nor the Bill of Rights give a right for marriage. So, according to this, the Bill of Rights, marriage is reserved to the states. So, again, and by the way, every time same-sex marriage, well, in most states, every time same-sex marriage came to the voters, they didn't vote for them. They either banned it or not approved it. They went against same-sex marriage. They voted down same-sex marriage every time it came down to the voters. Every time, most states, even in liberal California, we voted down. We banned. We voted down for a constitutional amendment even in liberal California. So, and that even passed in liberal California. So every time it came to the voters, we voted down same-sex marriage, because we know, the voters know, marriage is only between one man and one woman. There is no other marriage, and marriage is not a right, it's a privilege. Again, here, even in liberal California, voters voted down same-sex marriage with Prop 8. So that just proves every time. Again, so anyways, sorry for the rant about us in California, but just want. And the thing with gays, gay activists, if you really want true tolerance, why do you always want to go attacking Christians? You're telling us we need to be open-minded? It sounds like you need to be more open-minded than us. We're not quote homophobic. Seems like you must be Christophobic, because you're always trying to attack us, because we're just minding our own business, doing our own business, living our own lives, and you guys want to attack us, come to our businesses, knowing full well Christian-owned businesses will not approve of same-sex marriages, and you know full well she was a Christian, and you go to a county clerk who still has every right, who still has all the rights we have. Just because she's a public figure, a public citizen, doesn't mean she's not a private citizen. She's still a private citizen. She's still an American citizen. Kim Davis has the same rights as every one of us has. And she should not be punished for her religious convictions. Simple as that. Thank you and God bless.